Welcome back. The RICO Act was designed back in the 70s to prosecute organized crime, and it's arguably best known for its use in mob cases. But that's how the DA in Fulton County has charged all 19 defendants with violations of Georgia's RICO Act. The indictment lays out 161 acts it alleges were part of the racketeering conspiracy, including emails, phone calls, and tweets by former President Trump, his allies, that they carried out across multiple states. Joining me now to help us better understand the legal complexities, criminal defense attorney Dany Cevallos, former federal prosecutor and Superior Court Judge Carol Lamb, both are NBC News legal analysts. And with me from Georgia is former Georgia Attorney General Sam Olens. Thanks so much to all of you for being here. Really appreciate it. Carol, let me start with you. We've been talking about the fact that this is just a massive case. It's sweeping 19 defendants, 41 counts. How do you begin to prosecute a case this big, this sweeping?
Well, when you have that many defendants, there's some good things about it. There's some bad things about it. The good thing about it for DA Fani Willis is that it really does tell the whole story. Everybody who was culpable in all of this grand scheme in Georgia is a defendant in this case. Where it's not so much of an advantage is that it makes everything very unwieldy. It becomes a very unwieldy potential trial. Even pretrial, it's very unwieldy because you have a lot of pretrial motions that Dany can undoubtedly tell you about. And it's like a large animal moving underwater. It's even hard to schedule a hearing because you have so many defendants and so many attorneys in the case. But it does permit her to tell the whole story. I think one of the interesting things about this is we haven't seen a lot of evidence of people pleading guilty and cooperating here. Undoubtedly, there are cooperators. There are a lot of people referred to in the indictment as individual 1, individual 19. So obviously there are people cooperating, but we haven't seen a lot of guilty pleas being taken, and that may happen during the course of the pretrial proceedings.
Sam, let me get your take on that, because as we were just discussing in the previous segment, there has been some crossover between this indictment and the indictment brought by Jack Smith, the indictments, I should say. Do you expect some of the co-defendants to flip?
Well, one of the very interesting things is that Mark Meadows is a defendant in this case. He didn't really appear in Jack Smith's indictment. He certainly didn't appear as a defendant, and he doesn't appear to be described as a co-conspirator in the indictment as 6 others were. And I think the prevailing thought in the legal community was, well, he must be cooperating. But to have him appear in Fani Willis's indictment as a defendant really puts a big question mark on that, because you have to wonder, if he's cooperating in Jack Smith's case, why is he being indicted in Fani Willis's case? I think that's problematic, and I hope it doesn't indicate a lack of coordination between the two prosecutions. But yes, there's a question mark with respect to Mark Meadows, and with respect to the others, I think, given the fact that they're looking at potentially at least presumptive 5-year minimum mandatory sentence, I think there could be some movement on that front with some guilty pleas.
Sam, what is your take on that? Are you anticipating that we'll see some of the co-defendants flip?
So I think it's very likely that there will be some movement in that regard. As folks learn more about the 30 unindicted co-conspirators, I think that will add additional pressure. And I think that a lack of coordination with Jack Smith today should be expected, but one would expect more coordination potentially in the future.
Dany, if you were the former president's defense team, how worried would you be about that possibility?
More worried than he is. I mean, he's apparently going out, he's giving speeches. I mean, that is the curse of the defense attorney, to sit around and fret about a case when the client, especially in white-collar cases, doesn't seem to be nearly as bothered about it as the defense attorney is. So really, at this stage, there's no discovery yet, although weirdly enough, these cases, most of the general public knows what's in a lot of the discovery. We've known what's in a lot of this since the January 6th committee hearings. We've even arguably known about some of it since the impeachment, the second impeachment of Donald Trump. So the defense now waits, start thinking about motions that you're going to file. You know, you talk about the timing of this case. Let me just give you an example. In the New York case, Trump tried to, but failed, to remove the case to federal court based on a law that would allow a federal official to remove a criminal case against him to federal court. Now, he lost that, but it required time. It required an opinion by that federal judge. Now, that same statute appears to possibly allow not just the official, but anyone working for him to remove that case. So now what happens if you have 19 defendants seeking removal and the judge has to consider all 19 of those removals? That's just one thing, one motion, one example, aside from all the other motions that all these defendants may be filing. We've been talking a lot about Fani Willis wanting to go to trial in 6 months. For litigants, for the attorneys, it often doesn't matter what we want in terms of timing. It's up to the court. And this court is going to be dealing with a lot of motions, to say nothing of the fact that they've had a racketeering trial ongoing in the same county that has been in jury selection for 8 months. Not the government's case in chief, not the defense case, jury selection for 8 months.
Sam, let me ask you, the indictment lists 161 overt acts of conspiracy, including some tweets by the former president. I want to read you a few of them. One of them says, Georgia hearings now on, he mentions a news site, amazing. People in Georgia got caught cold bringing in massive numbers of ballots and putting them in voting machines. Great job, Brian Kemp. The vice president has the power to reject fraudulently chosen electors. Obviously, a lot of misstatements there. Explain how these actions and how these tweets could feed into this broader case that's being brought against the former president of conspiracy.
So, first of all, the former president attacked our governor earlier today, announced there'd be a press conference Monday in New Jersey, and continued the same false attacks post the indictment. I think what that shows is the value that was presented earlier in bringing a RICO case. It permits you to bring in all these issues to show what was occurring in the big picture rather than the small picture. It permits violations that technically related to other defendants than the former president. So by doing this over and over again, he's permitting the jury to literally understand why it's a criminal enterprise or why it is considered a criminal enterprise. And that's very beneficial to the prosecutor.
Carol, let me go back to you. Do you think that there will be additional superseding indictments? What are you expecting in that regard? And let me ask you about something that we've been talking about throughout the show, which is there a risk in this being so sweeping?
Well, I actually don't expect a superseding indictment in this case unless there's a defendant or more defendants to be added. It looks like the charges themselves are pretty comprehensive. So in the interest of keeping this case moving as quickly as I can, but I don't think it's going to be a quick case to get to trial. But in that interest, I wouldn't expect a superseding indictment. I want to be clear about one thing. The count one is a conspiracy/racketeering conspiracy charge. And the difference between that kind of charge and the other charges is that a conspiracy is a crime in itself. It's the agreement, and that is a crime. It's the agreement and a step taken in furtherance of that agreement to commit a crime. That is the crime. And so when Fani Willis lists all of these what are called overt acts, but they're acts in furtherance of that conspiracy, and she includes a number of things that occurred in other states, it's all very descriptive, but the jury doesn't actually have to find that all of those are proven beyond a reasonable doubt. They only have to find, in the case of racketeering, 2 that were part of the pattern, and in the case of a regular conspiracy, just 1 act beyond a reasonable doubt. So I think it's beneficial to Fani Willis to have included all of these acts as a descriptive tool, but she actually, even though she will put on evidence of all of them, she doesn't actually have to have the jury find all of them beyond a reasonable doubt.
That's a really important clarifying point. Dany, let me turn to you. You mentioned the jury. Talk a little bit about how jury selection works in a high-profile case like this. How challenging is it?
we already know that in another RICO case in the same county, that it is taking a long time to select a jury against in a case against a high-profile defendant. But I'm willing to bet that however high-profile that defendant is, he's not as high-profile as this defendant, meaning Donald Trump. So jury selection is going to be even more difficult when you factor in that the defendant, one of them, is going to require round-the-clock Secret Service detail the entire time. And then the other thing, perhaps at no other time in history have we had this much detailed research about jury pools. And by that, I mean, you can look at the results of the 2016 and the 2020 election to get an idea of how jury pools might go lean towards Trump or away Trump. Now, I caution that election results are not an indicator of whether a juror can put aside their prejudices or their thoughts about a particular candidate and sit in judgment of him or her. But, I mean, never before have we had this kind of data about what to expect from a particular jury pool, whether that be New York County, whether that be Atlanta, or if they remove out of Fulton County, which is not likely, the district encompassing Atlanta, the federal district. So this is really a fascinating time where you can actually get some real hard data about the kinds of people who may be sitting in judgment of Donald Trump and his co-defendants.
Sam, let me give you the final thought here. When do you think we will see this go to trial?
I think the former president's going to do all he can through his counsel and filing many motions to delay that potential trial. And as we've already stated, the federal officer removal statute will probably be the first attempt. It will be, in all likelihood, unsuccessful, but it will cause time. I think everyone in the case on the prosecution side wants it to occur quickly. If I were the court, I would want it to occur quickly. And I think similar to the case in D.C., the extent to which the president attacks the court or attacks the prosecutor may push the court to seek to have a quicker trial.
Well, that is an interesting final point, and we will leave it there. This is complicated stuff. Thank you so much, Dany Cevallos, Carol Lamb, and Sam Olens. We really appreciate your insights today.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.